Okay, so it looks like, Mr. Trudell, you are seeking equal parenting time on a essentially week-on, week-off basis,
Yes.
and alternating ability to claim the child for tax purposes.
And that part right
Uh,
there isn't set in stone. Like if we can't agree on it, I could care less about the taxes. I just want to have my son 50-50 parenting time, and I don't want to pay child support. Just because for the last 6 months I've had him for 50-50 and on her time, and I wasn't paying child support. So this is out of nowhere.
all right, well, hold on. So, Ms. Holmes, you did not appear when this was in front of the referee. Let me ask you, are you opposed to a 50-50 parenting time schedule?
Yes, recently things have come to light. Actually, the March 18th of 2021 is the day that I officially decided that I was no longer comfortable with 50-50 custody.
Why are you uncomfortable with 50-50?
Well, the day that on March 18th, I went to pick up Atticus. Cody, per usual, was not home. He was with Brooke. Atticus was with Brooke. And when I picked him up, Brooke told me that he had woken up in the middle of the night screaming and crying, burning fever. When I asked if she took his temperature to see if it was serious and needed to go to the hospital, she said no, because they were too tired. I don't feel they have a newborn in the house, and I don't feel that they have the time or the energy to take care of them the way that they need to be taken care of. I'm very concerned for his health while he's there. They have people in and out of their home constantly during a global pandemic. I picked him up a couple weeks ago. They had at least 20 to 30 people in their home, and that makes me very, very comfortable.
That's
All right,
unbelievable.
well,
A father requested equal parenting time, hoping to maintain a 50-50 schedule, avoid child support, and preserve the arrangement both parents had previously followed.
hold on. I'm not going to take testimony today. It looks like I may have to schedule a time when that can happen. How old is Atticus?
He will be
2.
3 in August.
3 in August, okay. All right, so in order for me to change a custody order, unless the parties are in agreement, there has to be testimony taken and a determination made that the requested custody arrangement is in the best interest of the child. Today is just a motion hearing where I find out if there's any kind of a reasonable basis for me even to go down this road. And given that there was actually the practice of shared parenting time for some period of time up until when it just stopped, that's a sufficient basis for me to order that parenting time be revisited. So what I'm going to do is schedule the matter for an evidentiary hearing. I would hope between now and then, whatever the concerns are, you can work them out and resolve them. I think it's in Atticus's best interest if the two of you are getting along. On the other hand, it sounds like there's reasons why maybe that's not taking place, but try to resolve those things.
Yeah, there are other.
One statement.
You can, but I'm not going to remember it. Go ahead.
That's okay. I just want this to be known. None of these concerns were ever brought to light until, and she still hasn't said this to me, but nothing was a problem until I asked for every other year taxes, and she literally told me that this was my fault because I got greedy. I could care less about the taxes. I just want everything to go back to the way it was.
Well, just
The mother opposed shared custody, raising concerns about the child's care, health, and living conditions, prompting the judge to schedule a full evidentiary hearing.
remember to tell the referee that at the evidentiary hearing. I'm sure you'll be interested in hearing, but I'm going to refer this to the friend of the court to conduct an evidentiary hearing on parenting time.
Now, if I have paperwork that I need to, because I actually have a statement from management of my work saying that I approached them on March 18th, telling them that I was no longer comfortable with 50% custody and I needed my hours cut. Cody didn't even ask to claim him on his taxes until March 25th. So if I need to turn in this evidence, do I need to do that, or how do I do that?
Uh, if you have documentary evidence, you would want to have it available at the hearing. If
Okay.
it's something that comes from a witness, you would want to have that witness available to testify at a hearing. They can
You
testify by Zoom, just like we're doing it here. Um, uh, uh, if you need a subpoena issued to make sure somebody's attendance is compelled, and this applies to both of you, just submit a subpoena to the clerk's office, and they'll send it up to me for signature. That will ensure that any witnesses, either who are not willing to come voluntarily or who perhaps need to show their employer something in order to get time off from work, that vehicle's available to you.
Can I ask a question? Are recordings admissible or allowed?
It depends on what's being recorded, but if it's a recording of something that Ms. Holmes is saying, absolutely, you can submit that. Similarly, if she has a recording of you, she can submit that. If it's a recording of somebody else,
Printed out text
hold on,
messages and stuff?
printed out text messages, absolutely, those are fully admissible.
What if it's a what if it's a recording of my son, because I record him every time I tell him he's going to.
Both parents asked about presenting evidence, including witnesses, recordings, and text messages, while the judge explained courtroom procedures and encouraged them to prepare everything carefully.
To his dad's, and he screams and cries and says he doesn't want to go. Is that
That's literally
if you have that, I would probably admit that.
okay?
that doesn't mean anything. 6 months straight, he was with me every day except for Tuesdays and Sundays. I have a literal text messages of that.
And things have fight. But if
All right, hold on, folks. Hold on. Save this for the referee. He's the one that's going to be hearing this. You'll be getting a notice of that evidentiary hearing. Have all your evidence present then. Thank you.
Okay.
It's a matter of Weaver versus Weaver. Both parties are present. We're here on Mr. Joel Weaver's objections to the support order. The objection appears to be valid. Looks like the calculation failed to include that Mr. Weaver is responsible for the support of another child. And absolutely, if that's true, which it looks like it is, that needs to be taken into account in doing the child support calculation. What I would typically do is just simply send this back to the friend of the court, tell them to recalculate child support with the correct information. Let's see. That was the only objection, wasn't it, Mr. Weaver?
That's correct, Your Honor.
All right. Did either of you have any questions for me?
I do.
Go ahead, ma'am.
Well, he just started a new job, so I don't know if that takes into effect, but,
Attention shifted to another family dispute, where a father challenges child support calculation after claiming responsibility for supporting another child had been overlooked.
I have some objections to myself, and I didn't know how to do that, but.
Well, we're here. You can tell me what they are, and I'll tell you if I can do anything about them.
Okay, well, one of them is like, I think it said in the court papers, like, I agreed to pay all the health stuff, and I want him to pay half of everything. Like, everything. Medical, everything. School stuff. You know.
Uninsured healthcare expenses are shared based on this current support order, which may change. The percentage might change when they recalculate. It's 51% by Mr. Weaver, 49% by you. That's the only thing we require is the uninsured expenses to be shared. Child support is intended to provide for all those other things that parents are responsible for. Sometimes parties can agree to share some other things, but the only thing we mandate is that uninsured health expenses be shared.
Okay. We just,
Um,
I mean, in
right.
order for joint custody, I just want everything
If there-
split in the middle.
If there are child care expenses, that can be addressed. I mean, are either of you incurring child care expenses currently?
I am, but we agreed to do it on our own.
Okay. All right.
Can I
Well,
ask,
I
Your
will.
Honor?
Sure. Go ahead, Mr. Weaver.
On the medical, with my new job I just started, it said I wasn't recommended, but I don't know, per the order, but it didn't matter to me. But
The mother questioned medical expenses and financial responsibilities, while both parents discussed childcare costs before the father revealed he had recently started a new job.
they're on my health insurance now. I'm just waiting on their insurance card.
Wonderful.
This is news to me, but
Well, I'm assuming it's good news to you, Ms. Weaver.
yeah.
What's the name of the new employer? Mr. Weaver?
Amazon LLC.
Will you be earning salary or be paid hourly?
It's hourly.
How much per hour?
It's 15.
And how many hours you expecting? 40 hours a week?
Yeah, close to that. But right now my average has been about 30.
Does it just depend on how much work they have for you?
Correct, Your Honor.
What's the contact information for your employer? Do you have that with you?
I don't know if I actually know the number. I'm sorry, I didn't actually think about that. I do believe I know the address. Well, no, that's the employee. I don't have a number for it, but I could get the address of its location.
Well, that's good. I'll take the address.
Okay.
The judge gathered updated employment details, including hourly wages, expected work hours, and workplace information, ensuring accurate financial records for recalculating future child support obligations.
Let's see if I can. Here. Number. Yeah, what's the address? Yeah. Address, please. Okay, it is 7009 West Mount Hope Highway, Lansing, Michigan 48917.
And when did you start there?
I just started on May 31st.
All right, I'll provide that updated information to the friend of the court. And ma'am, it shows you working at Folk Oil, is that correct?
Yeah.
And there's been no change in your employment?
No, not yet.
All right. You both realize that when you do have a change in employment, you need to notify the friend of the court?
Okay.
Correct, Your Honor.
All right, so I was just looking at the calculation.
After reviewing the updated employment information, the judge ordered the friend of the court to recalculate support using corrected income and existing child support responsibilities.
I have to run across the hall. I think.
Hello.
All right, I was just curious how much a change that is, and it will certainly impact the calculation. I don't know by how much, but I don't run these numbers. I just send them to the front of the court, and I'll give them updated information, and they will generate a new support order, possibly two. This one, let me see, this had an effective date of 5/1. So they might do one order effective 5/1 and another order effective.
The discussion then turned toward the divorce timeline, with both parents expressing frustration over delays while asking when the case could finally reach completion.
6/1 with the new income. So I'll make sure we get all of this over to them. You will still, hopefully that'll address all of the issues. Let me make sure of one other thing. All right, yeah, in your objection, you listed the case where you have the other child. I'll make sure they have that information. Any other questions?
Yeah.
Yes, ma'am?
With that, because Calhoun County has one too, and we were told that like Jackson County would take over it. Because, I mean, I don't think he should have two. You know?
No, he won't. There'll just be one child and one support adjustment to be made. Whichever county has the case will be the one that they'll use. I see from the information that says that Jackson County has taken over that. I'll make sure that the front of the court realizes that that's what we believe to be the state of affairs. They will check it out in any event. They have the ability to check for children on support in other counties through the system that they've got. I'll just make sure that they do that.
Okay. And then my last is, like, do you by chance know where we can get this divorce final though? Because we're both ready to be over it.
Let's see. Let me see when your complaint was filed. You should have gotten dates.
I haven't received anything. I don't know about
Hold on.
Dates.
Court records confirmed upcoming pretrial and trial dates, while the judge explained participation options and reassured both parties they could conveniently appear through Zoom.
For September is one meeting, and then another one's in October, I believe, Your Honor.
That would be your pre-trial and trial dates, which in a divorce involving minor children, a divorce cannot happen until 6 months have passed from the filing of the complaint. So that's the soonest we could get this wrapped up, folks.
Okay. So they haven't. So there's no court date then for that yet.
Yeah, well, according to what Mr. Weaver's telling me, he got a notice. I will verify that for you, ma'am. In just a second.
I got one.
Let me. When did you get yours, Mr. Weaver?
I got that immediately after submitting everything. The county clerk, that was part of the paperwork they provided me, and all parties got a copy with that notice as well.
Get it.
All right. Well, let me. I'll get this for you, ma'am, and you're going to want to write this down because these are important dates.
Okay.
Give me just a moment.
Yeah, I gotta get a pen. Okay. Whenever you're ready.
So just to verify, we're showing your address, ma'am, as 2701 Calhoun Road, Lot 36, Albion.
Yes.
Okay, so that wasn't the problem. All right, we have a pretrial hearing on September 23rd at 9:30. And then there's a trial date, October 7th at 1:30.
Is that
So
going to be in person, you think?
You will.
The judge outlined how agreements on custody, parenting time, property, and support could eliminate the need for trial, allowing the divorce to conclude much sooner.
Be able to participate by Zoom.
Okay.
If you wish to come in person, you will be able to, but you're not required to. We actually encourage you to participate by Zoom. That saves some travel for you. And we're going to keep using Zoom as long as we can for as many people who prefer the convenience. Use the same information to dial into that hearing that you used to dial in today. So at a pretrial conference, what I determine is it necessary for us to have a trial? If you're all agreed on division of property, custody and parenting time and child support, there's no need for a trial. You would just prepare a judgment of divorce that reflects all of those terms. Mr. Weaver would have gotten a blank judgment of divorce at the time that he filed the complaint. And if you're in agreement on the terms, you fill it out, you get it reviewed and approved by one of our friend of the court referees. And there won't need to be a trial if you're in agreement on everything. But I'll explain all of this again at the pretrial, so you really don't have to remember that. But the soonest you're going to be able to be divorced is June. I don't know why they gave you those dates. Those dates aren't going to work. Hold on a minute. Hold on. Maybe they will. I'm looking at the wrong thing. Pardon me.
Okay.
Oh, yeah. Those dates will be good. I'm sorry. I was looking at a later filing date, and I see now that this was filed in March. So 6 months later is September. So the very earliest you could be divorced would be 180 days after March 18th. So there's nothing really we can do until then. So when you come back for the pretrial, I'll explain all of this. In the meantime, we'll try to get this temporary order fixed, okay?
Okay.
All right, you both have a good day, please.
You too, Your Honor.
Thank you.
Closing the hearing, the judge confirmed the legal waiting period remained in effect, promised temporary support corrections, and wished both parents well before ending proceedings.